something. Mark DeVecchio's here today with me.
Who's your special guest?
I'm going to tell you in a second. Just it's a special, two special guests,
Oh,
two big gun lawyers,
wow.
even bigger guns than me, Mark.
Wow.
So Ron, we've been doing this show for 34 years. They offered me when I first started doing it, the syndicated. I go, who'd want to listen to my show? Now they won't let me syndicate it. But anyhow, getting back, one of the longest running legal shows. We were doing podcasts before podcasts were a thing. Of course, everyone could watch us on Facebook Live. We put it on YouTube. It goes over to Spotify, Apple Podcasts, Instagram Live. And we have two amazing lawyers with us. One's name is Seth Katz, and he is from Colorado. And the other gentleman is Adam Gomez. They were the two lead lawyers in the East Palestine train derailment case.
Wow.
And they are on the line. Adam and Seth, are you there? All right, great. All right, well, we wanted to have you on because we went to the NTSB meeting at the East Palestine High School the other day, and we were the only ones there, only lawyers there. We were kind of getting assailed. But I thought I'd have you guys on because I was getting a lot of questions. So, Ron, we're going to actually have them in the studio when they come. They're going to come here, and we're actually going to do a whole thing on it. But July 1st is a very important date, and I want everyone from East Palestine and in the community to know about July 1st. July 1st, and I'm going to let Seth and Adam talk about it, and you guys can brag a little bit about yourselves. They do mass litigation, they do class action, mass torts. It's a specialty in the law. And Brian was on the steering committee, but they settled the case, and so they made a class out of it. And you have to opt out by July 1st, okay? And then you have until, I think, what is it, August 22nd? Is that my date to opt in? Yeah. All right. So, and we're helping people fill out the paperwork. They have a center down there. If people aren't represented by lawyers, to go down there, they'll help you fill out the work. But what I want to talk to you guys about the most today, and what I tried to explain to people, is this medical monitoring component of it. So let me just turn it over to you guys, and I'll let you talk about the work you did, all the depositions you took. You could talk a little bit about Dalbert. And, I tell people this. You take a 20-mile radius, Mark, from our office, and have no train derailment. There's going to be a certain amount of percentage of people, 20-mile radius from where we're sitting right now in Canfield, Ohio, that get cancer.
Right.
Okay?
Sure.
So same thing there. There's a 20-mile radius, roughly. It's not as crow-flies because it's like the wind currents and stuff.
Right.
But there's going to be a certain amount of people that get cancer. It has nothing to do with the train derailment. They have this rule called Dalbert, and correlation doesn't prove causation. Just because you might get cancer doesn't mean that cancer was caused by the train derailment. And with that, I want you guys to brag a little bit about yourselves. Tell our listeners. Okay. Yeah, there was a lot.
The short answer is yes. The longer answer is, as Dave mentioned at the beginning, there's a coordinated effort between amongst 25 to 30 firms, and we collectively worked together and funded the work that it is taking to get to this point, including the experts, soil sampling, the experts to do other issues, experts to work on the derailment issues, taking the depositions, paying the court reporters, those kinds of things. So we've undertaken a massive effort. And Adam, I'll let you add on there because you were one of the heads of discovery. So you were really the quarterback coordinating everything in addition to doing some of the heavy lifting of taking a lot of these depositions. But so the short answer is yes, the lawyers involved in the class action all collectively fronted all the costs associated with the litigation.
Including our firm, Ron. Including our firm. So
Just to say, to that point about how much work has been done here and the expense that goes along with that, over the last 16 months, we were put in a rocket doctor by our judge. Here and making sure that if there was accountability to be had under the law, there was a decision made on that as quickly as possible. So, the time and expense associated with reviewing millions and millions of documents and discovery, taking over 100 depositions between the class representatives and folks that were employed by Norfolk Southern and the rail car owners over just a very short period of time, about 6 months or so of discovery, is a credit to all the lawyers that did work on this case. Like Seth said, 25 to 30 different firms and all contributed their resources to making sure that we can do that and ultimately get to this point and reach the settlement that we have today.
So if I understand it correctly, then, David, help me out here. Would these guys be like the front line here in dealing with this situation?
yeah, those guys were in the trenches dealing with the nitty and gritty. They're the ones that found the experts. So when you do a case like this, Ron, it's what they call a mass tort. So there's experts. Oh, my microphone fell off. There are experts that do modeling. What do I mean by modeling? So they hire an expert that'll come in and do a modeling, like where the prevailing winds were, who is in harm's way, what are the chances of different kinds of cancers arriving, what are the chances of contaminated soil, what are the chances of this, and there are I don't want to get too complicated, but there are stringent requirements in federal court. There are things that they were going to be able to prove and things they weren't going to be able to prove. For instance, one of the things that they initially sought, we all initially sought, was medically monitored. So when you file a federal complaint, a defendant can come in on what's called a 12B6 motion and ask, say, Judge, it is not the law in the Sixth Circuit where we can have a medically monitored part of this case. Okay? It's because people in East Palestine ask me, well, what happens 10 or 20 years down the road? Sorry, if you take the settlement, I mean, that's part of the DOJ settlement, and I'll let these gentlemen speak to it. But the judge dismissed that component of it because my understanding in the Sixth Circuit, we don't have law developed in a mass tort to have medically monitored people to keep it in. They did a yeoman's job, Ron. Look, Judge Benita Pearson put enough local lawyers on it to make sure that, not that I'm as smart as them because they're way smarter than me, but she did enough to know, yeah. No, it's not. I'll let them speak to that. It's not the law. And Seth and Seth, Okay, well, they have a center there, and yes, there's a website.
What's that
There's
website?
a website that they can go to that has copies of everything.
Yeah.
They can also go into the claim center and get help from the claims administrator or one of the lawyers there, in filling out their paperwork. But everything is available, even if they don't have the version that was mailed to them, or for some reason they didn't get one mailed to them, but they're still within their mileage radius. And that's www.palestinetrainsettlement.com. There's also a toll-free number they can call,
Which is?
and that's 833-425-3400. So having the form that was mailed to people is not a prerequisite.
All right, can you help out our listeners? Because when people say they disregard that form, you tell them how they can get a follow-up form. When do they have to have that filled out and in somebody's hands by? What is
August 22nd.
So it's not that far.
August 22nd.
No, the only reason I had these,
There's still plenty of time
right.
for people to get their claim forms in, and if they need help, claim comes in that.
And what does that form do when they put that form in? Does that mean you're a member of the class?
Maybe, Ron. There's advocacy within the advocacy. And what I mean by that is there's sort of a scoring system. And I'll let these guys explain a little bit more. But depending on the proximity of you to the derailment, they're going to go through first and distribute the money. That money cannot be clawed back by Norfolk Southern. And then if that money is not all used up once they go through this whole process, then they'll go through again and recalculate it. Now, that has to yet be developed and completely flushed out. So say someone was, 300 yards from the train derailment. They're going to get a lot more money for nuisance, trespass, if they had medical bills, things of that sort, than someone that was 10 miles away. You understand? And there's good, well, it's not 20 as the crow flies, is my understanding. Right, guys?
I mean, I have gotten emails from folks who, weren't directly affected, but they got a letter saying, okay, can they expect me to get medical problems or
Well, let me speak to that, Ron. They used census data. They used all of the things available to them, and in my opinion, they overshot. Meaning that probably more people got the notices than are actually going to recover. But that's a good thing. You want to overshoot people in the class, not undershoot them. You understand what I'm saying, Ron? Yes, they should still fill it out. There's going to be a claims administrator that's going to do all of this sorting and figuring out. And I'll let Adam and Seth speak to that. The only reason I'm having them on today is for people that have specialized damages or don't want to be in the class. They have to opt out by, is it Monday or Tuesday? I'm getting my days mixed up here.
Yeah, that's Monday, July 1st is the opt-out deadline. So the bottom line is anyone within 20 miles is potentially a class member and has rights to either participate and receive a payment if they're eligible, or opt out if they choose that they want to go their own way in the future at their own expense and hire a lawyer to do Norfolk Southern. If you want to opt out, the deadline for doing so is this Monday, July 1st. If you want to participate, if you want to receive the benefits under the settlement, that deadline is August 22nd, 2024. You can reach out to the website, to the toll-free number, go to the claims center, get all the help and resources you need to fill out the form so that you can maximize what you're entitled to.
I don't know, could you guys, David or the other two gentlemen, why would anyone want to opt out and do it on their own expense?
I am. Well, we had a couple clients that we talked to Beth Graham about today, because there's a business component of it, and we talked. It was a net business loss, but not everyone has a net business loss if you're a manufacturer. So the money you make in 2023, some businesses run 15, 20 months behind. So even though the train derailment happened in 23, they might not feel the effects of that until 24, 25. So there's a lot of little nuances and contingencies to it, but for the majority of people, you're going to want to opt in. And I'm going to let Seth and them talk about the modeling and what the experts said. And then I'm going to have them back in, and we're going to actually do a whole show before August 22nd about the settlement and how it works.
So the way that came about was we had several sessions with a nationally renowned mediator who's a former federal judge, and they were over the course of months, and in between there were phone calls and Zooms and back and forth and private meetings with that mediator. And this settlement amount of $600 million was the result of a mediator's proposal.
And that's a lot of money, Ron.
Yeah, and the parties, so the way that's a common thing when the parties don't get to the same spot on their own, that the mediator has listened to all the information. He's looked at everything we showed. He's looked at everything Norfolk Southern has shown. And he, based on his experience as a federal judge, came to this number and proposed it to both sides. And either side had the opportunity to say no to it. But what happened here was both sides ultimately accepted the mediator.
And so, Ron, there are various claims within the lawsuit. So there's called trespass to land. So if someone, say someone drives past your house and throws trash on your yard, they're trespassing on your yard. So there's a trespass component, there's a nuisance component, there's a injury component, and there's a business component. And then there's grading systems within each of those. Okay. So when you bring a case, Ron, you have the burden of proof. And when you bring a case in federal court, you have the burden of proving what you're saying is more likely than not with experts that can pass what's called a Dauber test. You just can't put up any willy-nilly expert up there. This person has to be credentialed. He has to have his work peer reviewed. And so each side has experts. Okay. It's not like we only had experts. They had experts pushing back on our experts. And so that's how they came to that figure. I think it's a fair figure looking at everything. I was involved in a lot of those Zoom discovery calls. I was involved in a lot of the looking at the pleadings and everything. And I would tell people, based on what I've seen and based on the injuries I've seen, that it's a very good settlement.
We obviously think this settlement is fair, reasonable, and adequately compensate the class for the injury and the allegations and what we would have been able to prove and what we would not have been able to prove. In addition to the class side of it, there's also the personal injury voluntary component that's available.
Clarify some thinking. So people that are in the area that are concerned, hey, I was close and I'm ready to, have like September 11th to the firefighters that they develop cancers later on as a result of their exposure. How are people in that immediate area? Do they get any type of coverage for that?
So the entire settlement, including the personal injury component to it, is going to be based on proximity to the derailment site. And so the short answer is yes. If people want to avail themselves of the personal injury payments, again, they have until August 22nd to submit their claim. And if they want to participate in that, they don't have to prove things that you have to prove in federal court. As Dan mentioned, the standards that you have to go through should be considered.
So
The-
what you're saying
If you have personal injuries, yes, because there's points in grading systems. It's complicated to explain on the radio, Ron, but they're going to go through like a first round. There's no clawback of this money. That money is gone from Norfolk Southern, if they have personal injuries.
We tried to make this process as simple as we can. So they don't need to have, this is not like 9/11 where firefighters were, on the pile.
Gentlemen, hang on a second. We have to pause for that. Gentlemen, stand by, please. Here, we'll let them answer that. Put them on hold. They can stand by.
All right.
Coming back to Las Vegas, September 20th and 21st. Presented by Progressive Insurance.
Baby Jimmy's Jordan's
Guards rookie John Kensey Noel Hobart in his first big at bat last night. That's only happened 4 times in franchise history. And Notre Dame and Michigan State will renew their football rivalry in 2026. Teams haven't played for the Megaphone Trophy since back in 2017. I'm Scott
I
Davidson.
don't know. I think he went with his mom somewhere.
Multi-policy district.
Big Jimmy. He's little Jimmy.
Protection in one voice.
Yeah. Right?
That's progressive.
When did little Jimmy come
Now, Alan Verne. On News Radio 570 WKBN. It's the longest running radio show that
Ready for our third visit again?
30 minutes, 5 to 6, answering your legal calls and questions. We'll get to those shortly. They brought us the guest here in the beginning of the program. And Adam on the end of our lines. Gentlemen, few words prior to our wait a second. I think I lost one. Unfortunately.
Who's still on, Seth or Adam? Adam, are you there?
Yeah, I'm here.
Okay, all right.
But let me ask you, Adam, one of you was saying one
designed this process to be as streamlined and as simple as possible. So you don't need to go sign up with a lawyer in order to fill it out and participate in the settlement. The claim form for an individual household is between 5 to 6 pages long, asks for very simple information. Most people will be able to do that from the comfort of their own home or submit it online. If you do need help because your situation is unique or you just have questions, you want to make sure you're doing it right, there's tons of resources available. Or the website, the toll-free number, but certainly the claim center has been set up for in-person assistance. It's located at the former site of the Family Assistance Center in East Palestine. The address is 191 East Rebecca Street, and it's staffed by the court-appointed settlement administrator who's got folks online in order, or in person rather, to sit down with you and provide information, help you walk through the forms. And it's also got the lawyers that were appointed by the court to assist with any legal questions that you might have, asking about what does the settlement cover, whether you're eligible, what are the implications, anything along those lines.
And
Obviously, if you feel like you want individualized counsel, that's your right to do it, and you can reach out to a lawyer and have them help you, but there's plenty of resources in place to make this a streamlined and efficient process for individuals on their own.
And Ron, I'm going to have them back, and we'll just leave it at this. And why don't you explain to the listeners the problems you ran into with the causation and the potential for further medical damages, and some of the problems you ran into in the discovery with that.
Yes. I'll try and keep it at a high level with the understanding that we'll come back and go through it in greater detail. I think there's a legal there's a legal question that's at issue, and then there's just a practical problem, right? The legal issue is, as Dave mentioned, the Sixth Circuit, which is the federal appeal court that sits over federal courts in Ohio, has ruled that medical monitoring is not an available cause of action
Under
for
Ohio
law. Under Ohio law, exactly. So that means that suing to set up a medical monitoring program where there's testing for a certain number of years for certain types of cancers is not available in Ohio like it might be in some other states. So that's legal challenge number one. Practical challenge is when you look at all the data that's been generated in the case. That is the data that the EPA put together, that we independently analyzed and reviewed, and the data that our own experts generated. The level of contamination doesn't show the amount of exposure for the amount of time needed to reasonably prove an increased risk of these cancers that are associated with these products. It's a very, very high bar to prove that increased risk. And, it's always a question in any case whether you're going to get there, whether the evidence is going to bear it out. And in this case, it was especially tough, just given how short this release was and how far the chemicals were dispersed over a wide-ranging area. So you take both of those things together.
That might be good news for people in the area to hear as well.
Yeah.
That,
Yeah,
that's
these guys
probably
did an amazing job, Ron.
It's definitely something that folks, should be heartened by in terms of thinking about their long-term prospects for living in the area. In the absence of data and information, it's understandable that folks think that the worst has happened, but what we've turned up suggests that that's not the case. And, that's why there's limited medical damages. But nevertheless, that exposure program or that personal injury program that's been referenced a couple of times here is a recognition that there still was exposure to chemicals, and they may have caused some acute personal injuries, folks with runny noses, sneezing, gastrointestinal problems, headaches, you name it, and they deserve to be compensated for that. So if folks want to participate in that program, we encourage them to do so. We think that it's, again, fair and reasonable settlement for those kinds of injuries, and they should be mindful that the reason there's not more in the way of medical damages is because the data doesn't support it.
And that, like I said, that is actually, Dave, good news for the area to know that that's
so. Just so you know, Ron, when you bring a case, you have the burden of proving what you're saying is more likely than not. And our experts and our modeling would not support what a lot of people are most fearful of. Now, that doesn't mean it couldn't happen. It just means we couldn't prove it in court. So it's a high bar, and it's very technical and very costly. So I think these guys did a yeoman's job. I was on a lot of the conference calls. I was watching the pleadings. Beth
Right,
Graham was, go ahead.
David, before you let him go, I got another email question, and I want to make sure they address. And the guy says, I live within the 20-mile and receive the letter and plan on not doing anything. However, my question is, I am a contractor and work at the job site every day. Ask the attorneys if I should opt out. Thank you.
Well, unless he has medical bills and medical injuries, I would not opt out, because it's going to be very costly for that gentleman to prove his case. He's not saying he has any injuries right now. So if he doesn't have any injuries, you don't, a personal injury is like a hockey game. No blood, no foul. Okay. You have to be injured to bring a claim. Just because you were near something and you weren't injured, you don't get any injuries, Ron. For instance, if you almost get hit by a car, but the car doesn't hit you, there's no injury there. So if he was working on the site and he hasn't gotten sick and hasn't developed any medical bills to this point, our experts say the likelihood of him developing anything is very low.
Could you address one part of that, though, David, which I think is kind of foolish on his part? He says, I live within the 20 miles and receive the letter and plan on not doing anything. I would advise him to fill the letter out as opposed to the course of action he's talking about.
There's more people that got the letter than should have. So that doesn't mean you're going to get money. So it's based on proximity.
But fill it out.
Fill it out and send it in, and we'll figure it out. It'll be figured out. It doesn't cost you anything to fill it out. The forms are very simple. I've done it for a number of my clients, and thanks to Adam, I have had a number of my clients leave me too, but that's okay.
Well, Adam, congratulations. I knew he sounded like a pretty good attorney to me.
But we'll have them back, Ron. I promise.
All right.
You have any more email questions? If not, these guys are so busy. I want to let them go.
All right.
We'll open it up for questions. But Adam and Seth, if you guys can come back and do the whole hour with us, I'd really like that. Closer, like in July or early August, before those forms have to be in.
All right.
Yeah, we're happy to. And if I can, just before we get off, I want to echo what was already said. Doing nothing is probably the only bad option, right? You've got rights. Make sure that you exercise them one way or the other, but don't just sit there and not do anything. File a claim if you want to participate. And there's so many resources there. We're happy to help.
Yeah, fill the letter out. Don't ignore it, because it's just foolish to do that. Thank you, Adam.
Thank you,
Adam.
Adam.
Your time.
We'll have him back.
Seth, are you there?
Can I chime in before we hang up?
Yes.
So I agree with Adam. If you got the letter, you should participate. Doing nothing is not a very good option for you either way. Now, one thing about the personal injury component to this that's available to people is you don't have to have had a current injury. You don't have to have gone to seek medical treatment. You don't have to have had any symptoms. You don't have to come forward with medical records. So I want to make sure people understand that, because I'm not sure that came through in what was being said. That component is there and it is available to people regardless of a present injury.
But it's a proximity level
for
correct?
People to participate in.
But Seth, it's a proximity level, correct?
Correct. If you were there, and it's only available to people in the first 10 miles.
Right.
Then it is available to you.
Right.
Without having to say, here's my report from the emergency room or anything, correct?
Without having to produce any medical records. All you have to do, if you want, is fill out a claim form that says, I was there, because it is not for past injuries only. It's partially for past injuries, but it's also for a future injury if you want, because you'll be releasing your right to sue in the future.
All right.
So for those few people that might get sick, for those few people who might get sick as a result of this, because remember, the background rate in the U.S. of getting cancer regardless of where you live, is somewhere between 1 out of 3 or 1 out of 4. So it's somewhere between a third and 25% of the people will develop some kind of cancer.
Regardless of a
And
train derailment,
it's important to know.
right?
Go ahead, Seth.
It's important to know it's available without proof
Right.
that you have any current injury.
I mean, that's a key element, David, that he just mentioned. So if you're within that 10-mile radius, you don't have to have a doctor say you have this problem. You can just fill it out.
That's
and,
correct.
why
But if
wouldn't
you have
why wouldn't
medical
you do that?
bills, there's a great, and if I'm misspeaking, please let me know. But if you have medical bills and can show injuries as opposed to just nothing, you might get more. Okay, there's going to be a grading system by the claims administrator.
Okay. All right.
We're going to have you guys back on, I promise. Okay.
Seth, we appreciate your time.
And
I don't know if you're still with me here.
Adam,
I know I
thank you.
let Adam go.
Happy to be on.
All right. Thank you for your time. We appreciate it. All right. So
Thank you.
there you go, Dave. We'll get rid of him. We got rid of him. Okay. But I think they answered a lot.
All right. Is anyone going to come in and do the show with me? They left me, Ron. They left me all alone.
Before we get to any of that, though.
Once again, all the way to the firm on my back. No Mark, no Frank, no. Brian's even in town. The big gun's in town. No Leo. I'm all here all alone. Always all alone.
I'm getting ready to leave myself, so if you don't knock it off. Anyway, let's take some calls. Dave, are you ready?
I'm ready.
All right, you're on the air with the Legal Show. Hello, what's your question?
Yeah, I was wondering how much is a disillusionment?
So Mark was here. It just depends.
It's always cheaper than a divorce, and basically, just for our listeners, Dave, that means that the husband and wife agree on a settlement, basically,
on everything.
Right?
On everything.
Yeah.
If they disagree on anything, that goes away. Okay. So
Right.
at the last moment, if one spouse says, "Well, I don't want to disillusion," then that disappears.
All right. You're on the air with Attorney Beatrice. Hello.
You talking to me?
Yes. Your question, please.
Okay, I don't have a question, but I have been listening to the people that are a whole lot smarter than me about the train derailment.
Yeah.
Yes, sir.
And as someone who has been in the railroad car repair industry for 40 years, I just have some questions to ask. One of which, as we started with the heat trace numbers of the bearings that were pressed on the axles.
So
Number two,
I think that's happened. I think they've changed. Hold up a second, caller. I think they've changed some of the federal law on that. I wished you would have been at the NTSB meeting at East Palestine High School the other night. They certainly would have had the direct answer to that. I know Senator Brown and Senator Vance have put forth some new regulations specifically regarding the issue that you're talking about. So I would suggest you either call Senator Vance or Senator Brown's office to see if there's new regulations or some new laws that have been passed. I know both of them have been working very hard on it.
Okay.
could I have another question,
Sure.
please?
What is it?
There's certain criteria for hauling railroad wheels on flatbeds. You cannot use chains anymore. You have to use straps.
Okay.
How were the wheels hauled?
All right. Well, yeah, Dave wouldn't have the answer to those. I got it.
I don't have the specific answer to that, But you could go to the website. The NTSB has some information on it. I wished you were at the NTSB meeting the other night at East Palestine High School, because they were answering
I've been trying.
All right. I think we did the best we could do with him. From my email, Dave, it's probably a generic question. How much will we, from the emailer, how much will we get for being within 10 miles?
I don't know at this point. You're going to get more, and then they're going to be like a second round. They're going to keep going round until all that money is used up. So
All right, but you can't give the
there is a table
ballpark
there, but it could go up depending on if the money's depleted or not through the first round. But hopefully people could start getting checks in their pocket by Christmas.
Can you give them a ballpark number or not? Just
I'd have to. I don't have those numbers memorized in my head. There is a court order on it, and it is thick. But it's on the website, I believe, the court order, and you can read about it there.
All right, with Attorney Beatrice, you're on the air. Hello, caller. What's your question?
Hello?
Yes,
hello.
Your question.
Hi. Yes, my question is, I have 6 beneficiaries on my will, and I was just wondering if, for instance, my brother, and then he has a family. In the event, God forbid, he should pass, would that money go on to his family or end with him?
I don't know. I'd have to see your will. So if you can make it that it ends with him or it goes to his heirs, it depends on how your will is written. It can be written either way. Most lawyers, so say you have 3 brothers, and those 3 brothers each have 2 children. So you'd split your estate into a third, and then if one of the brothers died, the 2 children would split the third. That's usually how most wills are written.
Here's what happened. I did see an attorney, and it didn't go well. So anyway, I went to the bank, and the bank the money's in the bank. The bank supersedes the will, from what I was told. Is that correct?
It goes outside. It's a non-probate asset at that point. It doesn't go outside of the will. The only thing that passes through a will is probate property. So if you have a payable on death account or joint tenants with right of survivorship on your deed, that's non-probate property, and that goes outside of the probate court. But that might not go to his heirs. So that's how you got to watch it.
At this point, this is what I did then. I went to the bank the next day, and I said, they said that the bank supersedes the will, therefore the monies could be divided among my beneficiaries. So as it stands, I've got these 6 beneficiaries. My brother is one. And in the event of his passing, then that would end with him. Then is that correct?
Unless
is this on your bank? This isn't in her will, Dave. Is this in her beneficiaries that she put down on her?
She could put in
account?
him or his beneficiaries. So I leave this bank account. Okay, if you just put in him and not his beneficiaries, then if he doesn't outlive you, then his heirs get nothing.
Okay, gotcha. All right. That's exactly what I needed to know then. Okay. Well, thank you very much.
Thank you
really
for
love your
listening, and
program.
thank you for calling in.
Right. That's that's a reminder for everybody. If you have a checking account or a bank account or whatever, make sure you fill out the beneficiaries and update them.
What I tell people all
divorced.
the time, we just represented a gentleman who has a food truck, and his father was a police officer and a mechanic, and they accumulated 7 figures. Even if you are a middle-class person and you are frugal, you can accumulate a lot of wealth, and you shouldn't poo-poo it. I mean, you shouldn't piecemeal your estate plan. You should sit down with a lawyer and do an entire estate plan. Okay.
Right. You know, the guy that has close to 7 figures, you say, from hard work, and you know how he was able to accumulate that? He never bought a big boat.
There's some truth to that. I could probably be retired now, Ron, had I not gotten into boating. Brian Kopp reminds me of that every single day. He actually made me feel so bad. He said, Dave, you spend such stupid money on that boat that you could go live at a penthouse in New York City for a whole year and not spend as much money. So thank you for making me feel bad for blowing my money on a boat. I appreciate that, Ron.
Yeah, I'm glad I could help Brian out there. Okay, you're on the air with Attorney Beatrice. Go ahead, please.
Hey, Rob, Monty Christian's head up.
All right. You're on the air with Attorney Beatrice. Go ahead, please.
Hello, is that me?
Yes,
Yes,
sir. What's
sir.
your question?
Okay, this is about the NTSB hearing the other day.
Were you there?
I want to know what were your thoughts on the NTSB hearing findings?
So the NTSB's findings aren't necessarily related to compensation of individuals, is the best way I could say it. Their goal is to find out what caused this accident and what can we do in the future to make sure this accident doesn't happen again. That's sort of their mission. The mission of plaintiffs' lawyers is what happened, what can we prove, how can we compensate people? You understand? So they said some things that we were happy with, and quite frankly, they said some things that as a plaintiff's lawyer, I wasn't happy with. But their job is different than my role. You understand?
Yeah.
Okay. Were you
Can I
there,
ask one more
sir?
question?
Yeah, one more question. What
yes,
is
sir.
it?
Could the findings of the NTSB mean additional lawsuits, penalties, or fines against Norfolk Southern, or any criminal charges for withholding critical information from the incident commander before the vent and burn?
So I don't think they've recommended any criminal charges when this isn't something that happens a lot. And so, you know, people are making on the spot calls. When you're making on the spot calls without any contemplation, generally that doesn't lead to criminal liability. But this litigation ends it. If you don't opt out by July 1st, then you're going to be barred from bringing any kind of case. And believe me when I tell you, the expenses were enormous. Enormous.
All right, so you're better not to opt out. All right, thank you, my friend, for your call. Dave from the email. People in Pennsylvania are saying even if we are not affected, we should file, I guess he's talking about that paperwork, as Norfolk and Southern will give out $15,000 as a payout. Is this true?
Ron, first of all, Norfolk Southern is paying out through this lawsuit. Then they had a family assistance center that paid out separately, but they get some set-offs for that. Okay. So what I want to tell people is go to the website, read the order, and those figures that are in the order are just tentative. There's a lot more that has to be done on this case, but hopefully people could start getting money in their pockets by Christmas. That is the goal of all of the plaintiffs' lawyers.
All right. So with Attorney Beatrice, you're on the air. Hello. Question.
Me?
Yeah. What's your question, please?
Okay. So I have a situation where essentially I was threatened by a police officer. It was retaliatory, but he said he would kick the door down. I was just wondering, what is sufficient probable cause to obtain a warrant? Like, would it be easy enough for him to get a warrant on something bogus?
Well, they cannot. Your home is your castle. You have the most constitutional protection in your home. But the Fourth Amendment has a list of exceptions to it. You have less constitutional protection when you're in your car, not as much when you're walking in public, but you still have some constitutional protections. So if you're in your house and they want to come and search your house, you're allowed to say, no, you cannot search my house. Do you have a search warrant? No search warrant. Goodbye, get off my property. You're totally within your rights of doing that. If they have a search warrant and they present to you a search warrant signed by a judge and you prohibit them from coming in, you run the risk of getting an obstruction of justice charge. Now, whether or not that judge was right, hold up a second.
Would it be for him to obtain a warrant on something bogus?
Well, when you say something bogus, if he lies to the judge and he got a search warrant, and then you hire a lawyer afterwards and the lawyer finds out that he lied to the judge, then he's going to be held responsible for lying to the judge. But the time to assert your constitutional right is not when he's at your front door with a warrant. Whether or not you think it's bogus, he has a warrant signed by a judge.
No, I understand.
He's coming into that house one way or another.
All right. So there you have it. I'm running out of time, Dave.
Tomorrow
Thank you,
morning
caller.
on WFMJ Today, I'm going to talk about the realty building and what's going on there. I'm going to talk quickly about the East Palestine case and the opt-out by July 1st. So everyone join me at 6:40 tomorrow morning.
And you might talk a little bit about your boat too, right?
Whatever.